Morning, everybody, and welcome to this webinar. I hope you can all hear me. This is on planning enforcement orders, law and practice, with me, Alex Williams, and my colleague, Joe Cannon. Thank you for joining, and we very much hope it's useful to you. Joe and I are aiming to stop by about 12 o'clock. We are aware that there is such a thing as Zoom fatigue, and we don't want to detain you for any longer than an hour. So we will talk for around 45 minutes and we'll leave time for questions at the end. We're aware that some people, when they signed up, had asked questions of us. We've done our best to answer as many of those as we can during the presentation itself. We'll deal with a couple of them towards the end as well. And there is a Q&A function in Zoom where you can type your questions as you go along. So if there's anything that you'd like to know, then by all means, type that out and we'll address it if we can. So in terms of the content then, topics are as follows. First of all, Joe will start by talking about the background to the legislative regime surrounding planning enforcement orders, and then the requirements for applying for a PEO. I will then talk about self-certifying the date for time limits purposes. And in connection with that, the leading case of Tanna and Richmond and what that means. Joe will then talk to you about the alternative route of Welwyn Hatfield involving cases concerning deception. And then we'll end by discussing practical tips for LPA investigators, after which we'll have the Q&A. So without further ado, I will hand over to Joe.
Thanks very much, Alex. Morning, everybody. Thank you very much for coming along. Just a bit of background to the background. The reason, or what prompted this webinar was both Alex and I dealing with planning enforcement orders on behalf of clients in the last few months, and both sets of instructions being clear that that particular local authority, different ones, I think Alex one for Essex, mine one in Devon, they hadn't done a PEO before, and in fact, having a look at the various authorities, it's pretty clear that there haven't been very many of these. And it's evident from lots of the questions that you've asked that for lots of local authorities, this is a power that isn't very well used. And so both Alex and I, having chatted to each other about our cases, actually the truth is me chatting to Alex to ask for his help, because he was the one who did it first. We thought it might be useful to just talk about what this power entitles a local authority to do and some of the issues that surround it. So that's the background to the background. Moving on to the background itself, lots of you will know that these powers were introduced by the Localism Act, came into force in April 2012, and amended by insertion the enforcement section of the Town and Country Planning Act. So it inserted after the very well-known 171B about time limits, which is the 4-year and the 10-year rule, which lots and lots of you will be very familiar with. It inserted paragraphs BB to BC, which in effect is the statutory framework for planning enforcement orders. And it came about, by and large, in the wake of those two notorious cases, Beasley, which is known as Welwyn Hatfield, and Fiddler, which was down in Kent. Fiddler was the guy who built a castle and hid it behind hay bales, and Beasley was the guy who built a house inside a hay barn. And in each case, they sort of knocked down the outer shell. Ta-da! This has been here for 4 years. Please can it stay? So this is a legislative response to that. And in due course, I'm going to talk a bit about how those cases might still be relevant. In very short, the powers enable a local authority to apply to the Magistrates Court for a planning enforcement order where there's been deliberate concealment. And the effect of a PEO, if you get one granted by the Magistrates Court, is to, in effect, extend the time limit, either extend or disapply, however you want to put it, for a period. And again, I'll talk a bit more in a moment about exactly how that works. So the time limits, and this is definitely teaching grandmother to suck eggs. I know you all know about this, but the basic rule in section 171B is that there are two rules in terms of for how long a local authority can pursue enforcement action, or until a development becomes immune, which is the language that's often used. The time limit or the immunity period is 4 years. So if you can, if a development can hang about for 4 years without the local authority taking enforcement action against it, it is immune. If it's building operations or engineering or mining on or over land, that's the general rule, or a change of use of any building to use as a single dwelling house. And lots of you will know about the various lines of authority, starting with Arran District Council and Brown, about what exactly it means to change use to a single dwelling house. The idea behind that one being basically that if you can make somewhere your home and go for 4 years without that being enforced against, then I think it's thought that it would be unconscionable to require you to stop. Any other breach of planning control, i.e. anything not mentioned in the 4-year rubric, carries a 10-year immunity period, and mainly that's changes of use other than use of a building to use as a single dwelling house. So that's the basic position, meaning that if you try and enforce against some category A development after 4 years and 1 day, a ground D appeal to an enforcement notice will succeed, or a certificate alleging out of timeness would have to succeed. And similarly, with any other breach of planning control, 10 years and 1 day would be too late to do so. And of course, in both Beazley and Fiddler, the people themselves, Messrs Beazley and Fiddler, waited until the 4 years had elapsed and a little bit before the big reveal. And so those cases were all about quite how those time limits should work in those cases. Next slide then, please, Alex. What happens if, and this is really the heart of the PEO, what happens if a local planning authority is prevented from discovering the breach in time to take enforcement action? Of course, in both Beazley and Fiddler, they were hiding something. One of them was hiding a castle behind some hay bales, and the other one was hiding a large house inside a barn. So what can a local authority do when presented with, or when discovering? In both of those cases it was presented with, but it could just as easily be discovering a breach of planning control out of time, so it's alleged, but there is evidence that the local authority have been prevented from finding out about it until now. What can they do? Let's get rid of Faye Dunaway, or whoever that is, and go to the next slide. Well, one of the things they can do, and the main thing that we're going to talk about this morning, is that they can apply, as I said, to the Magistrates' Court for a planning enforcement order. And if they get that order, then it allows that local authority to take enforcement action, notwithstanding that the 4-year or the 10-year rule, as the case may be, has in fact expired, but they can take any enforcement action at any time in what's called the enforcement year. And the enforcement year is specifically designed, it's a slightly clunky phrase in my view, because it's actually not really a year at all. It's the period of one, well, it is a year, but it is a delayed start year for some reason. So it begins 22 days after the order is made, and it then runs for a year. So if you get the order on the 1st of March 2020, but for the order you're out of time to take enforcement action, then you can take enforcement action, notwithstanding the out of timeness, from the 23rd of March 2020 for 1 year. So that's the effect. If you like, it disapplies the time bar for that period of 1 year. And by enforcement action, mainly we're going to be talking about enforcement notices, but as I understand it, it could just as much be stop notices, so on and so forth. But by and large, we're going to be talking about enforcement notices when we've got PEO. Next slide, still background really. If this is the effect of a PEO, if you're successful in persuading magistrates to grant a PEO, as I've said, the local authority can, during the enforcement year, so for that period of a year starting 22 days after the order is made, they can enforce in respect of the apparent breach, so the thing that founded the application, so for example, the conversion of a holiday dwelling into a full-time home, or any of the matters constituting the apparent breach. So you don't have to enforce, pursuant to the PEO, all of the things that you got the PEO on the basis of. So you can choose to only pursue one or more of those options. I mean, that will be something that will be extremely fact specific, but there is you aren't bound to enforce against all of the matters on which you obtain the PEO, and that can be important in terms of taking action. And of course, I just pause to say that the test of expediency, whether it's expedient to take enforcement action, continues to apply regardless of the fact that you've got a PEO. The PEO doesn't remove any of those requirements. So even though the time bar is lifted by the PEO, you still have to, as a local authority, consider whether it's expedient to take enforcement action. And I dare say it may be expedient to take action in respect of some, but not all of the breaches, for example. And that power is there, or that sort of possibility to do that. Next slide, please, Alex. Just a couple of NBs here. What a PEO doesn't do, well, basically all it does is lift that time bar. It doesn't prevent the local planning authority taking enforcement action under the normal time limits. So you could apply for a PEO early and still pursue enforcement action in the normal way. It doesn't affect those rights at all. And as I've said in the next bullet, you can apply for the PEO and one can be made even if the normal time limits haven't yet expired. You don't have to wait until they've expired before making the PEO. You can make your application in anticipation that the time limit, I mean, I guess you would only do it if the time limit was relatively imminent, but it doesn't stop you pursuing enforcement action, either applying for the PEO and or pursuing enforcement action before those time limits have expired. So that's the background. What does the court require you to do, or what are you required to do in terms of an application? Well, first of all, you have to be satisfied that there may have been a breach of planning control. And we've just underlined the may have been there. There isn't any need for certainty or beyond reasonable doubt or anything like that. As you can see, this is Homer Simpson looking suspicious. I think you probably need a bit more than a suspicion. But I just make the point really that the test is relatively straightforward and relatively gentle in terms of the evidence that you have to have. You have to be satisfied, I guess, that there may have been a breach of planning control. So you don't have to go so far as you might have to in other circumstances. Certainly no need for certainty. Next slide. You have to apply, and this is, Alex is going to talk about this in much greater detail in a moment. You must apply within 6 months of having received sufficient evidence of the breach to justify the application. Now, this is important because what this does is pose the question in each case: what is sufficient evidence? At what point? And remember that sufficient evidence is of the breach. So you have to have got to a point where, in effect, your cause of action has accrued, to use lawyers' language. You've then got 6 months. So this isn't an open-ended time. You can't just sit on it. You do have to go along to the magistrates with relative alacrity once you've got sufficient evidence of the breach. But at the same time, of course, and this is what Alex is going to talk about in much more detail in due course, you have to be satisfied that there has been deception, because you can't just apply for a PEO because you've dropped the ball and the time limits have expired. You have to be able to show that there's deception. Next slide, please. And the only other requirement of form is that you must serve copies of the application, so not the order yet, but the application on the owner and the occupier of the land, just as you would with an enforcement notice, and on any other person having material interest in the land. So in exactly the same way as lots of you who work for local authorities will go through the office copy entries and make sure you've got all of the people with an interest in the land on your service list, you have to do exactly the same with a PEO application, which that's the application to the Magistrates Court. But that's all there is in terms of requirements of form. Next slide, please. What does the court have to do? Well, of course, the first point, and this is a point that a couple of you make in your questions, is how do you get the court interested at all? Well, that is not always straightforward. They won't have dealt with very many of these. As you know, magistrates courts aren't really functioning at the moment, and even when they are, Arguably, they don't really function very well anyway. My experience, and being a planning and licensing lawyer, I deal with the magistrates a fair bit with kind of quasi-criminal stuff, breaches of enforcement notices, licensing act stuff, and generally anything that's not a Section 18 wounding trial, the magistrates are not terribly interested. So you might, if you make this order, have to work quite hard to get the front desk at the magistrates court interested in listing this and accepting your application. But once you've done that and the matter is in front of the court, there's a two-stage test. This is Section 171BC. Keywords here are deliberate concealment. So you have to have sufficient evidence to satisfy the court on the balance of probabilities that there has been deliberate concealment. But the next words are also potentially quite important: to any extent, by any person or persons. So it doesn't need to be deliberate concealment of the entire breach, and it doesn't need to be deliberate concealment necessarily by the owner or the occupier. And it's the concealment has to be either of the apparent breach itself or of any matters constituting it. So even if some of what's been done has not been concealed, if you can show that some of the matters constituting the breach or the complaint, the breach of planning control, have been concealed to any extent by any person deliberately, then the test is satisfied, the first limb of the test. The second limb of the test, which in both mine and Alex's experience and view tends to be satisfied relatively easily, is that it's just to make the order. I suppose that leaves open the possibility that limb one is satisfied. There has been deliberate concealment to a certain extent, but there's some extenuating circumstance or some kind of special reason why it wouldn't be just, or in the interest of justice, to extend time and allow enforcement action. My feeling is that ought to be pretty rare, given that you don't get to limb two until you've got deliberate concealment to an extent by any person of the apparent breach and so on. Cases where it will not be just to allow, because we're not even requiring a local authority to then take enforcement action, all this does is allow them to do so. It's a rare case where it won't even be just to allow them to do so. I suppose the other thing is there might be evidence of some kind of wrongdoing or conduct of which criticism could be made by the local authority. I suppose that's the other way in which a magistrate's court might say, well, yes, there's been deliberate concealment, but we don't think it's just to make the order. And as I've said, the standard of proof is the balance of probabilities. You're not dealing with certainty or sureness here. The standard is as you'd expect in planning, which is the balance of probabilities on that point of concealment. Another slide, isn't there? Is if you're successful in persuading the magistrate's court to make the order, then the order itself must identify control and state the date of the decision to make the order. The date, of course, is hugely important because of the calculation of the enforcement year and the identification of the breach. Well, you can see that that's important, but those are really the only requirements of form. And I think in both Alex's and my case, we advised our clients to put in a draft order with the application for a PO. The magistrate's court will not be used to doing this. They don't have a standard form. They won't have a precedent. So you would probably give yourself a head start by just drawing up an order that they can basically just insert the date and then endorse or sign. That's my bit. You'll have noted from what I said that this question about when the cause of action arises, when it is that you can apply for a PO, is going to be totally central to most of these cases and will turn in each case on the evidence. And so Alex is going to talk to you now about how you go about self-certifying the date on which the right to apply for a PO arises.
Thanks, Joe. So as with any application to the court, time limits do apply. As Joe mentioned, under section 171BB of the TCPA, the application for a PO has to be made within 6 months, beginning with the date on which evidence of the apparent breach of planning control sufficient in the opinion of the LPA to justify the application came to its knowledge. I will break that down in a couple of slides' time and explain what that means in practice and in particular what it doesn't mean. But for now, just note those underlying terms. It's a statute that, or a provision that very much places the ball in the local authority's court. It's about when the local authority came to evidence that in its opinion justified it making the application for a PEO. So the starting point is that this is something that will largely be within the LPA's area of discretion. We also, sorry, that's the statute there, the provision there. We also, as Joe mentioned, LPAs are also able to self-certify the date. It's up to the LPA to, if it wishes to, provide a certificate basically explaining what that date on which it came to the evidence was. And we see this in section 171BB2. So a certificate which has been signed on behalf of the LPA and which states the date on which evidence sufficient in its opinion to justify the application came to its knowledge is conclusive evidence of that fact. So that language, conclusive evidence, is obviously very clear. Parliament could scarcely have been clearer in its language. But this question of when a court can look behind a certificate has taxed the courts quite a bit, and there is arguably some confusion actually in the case law as to what the courts can and can't do. But the headline point there is that, again, this issue of time limits, that when the 6-month time period begins to run is very much within the local planning authority's control. So what do the time limits mean in practice? Well, here are some common mistakes and sort of points of confusion. What the TCPA focuses on is not when the local planning authority knew of the breach. Okay, the question is, when did the LPA have sufficient evidence of the breach? Those are two different things. A local planning authority may know of or suspect a breach months or even years before it's conducted its investigations and feels that it has enough evidence to bring a PEO application. So they're very different time points there. And what the TCPA is looking to is when it had sufficient evidence to bring the application and not when it knew of the breach. Secondly, the Act also focuses on whether the evidence was sufficient to justify the PEO application being made. Now, that's very different to saying, did the LPA have evidence sufficient to suggest a breach of planning control? Once again, the LPA may have some sort of evidence that suggests a breach of planning control. That may be months or even years, however, before it feels it has enough evidence to bring a PEO application. And it's that latter point that the Act focuses on. And thirdly, as I've touched on already, the question is whether the LPA regarded that evidence as sufficient, whether the LPA regarded the evidence as sufficient, and not whether a court would. So it's up to the LPA to tell the court through its certificate when it decided that it had enough evidence to bring the application. And finally, the certificate is conclusive evidence of the date on which the 6-month time period began to run, but only if that certificate is signed and dated. So there are formal requirements that apply there. And as we'll see later, if a certificate doesn't contain that date, then it will fail for being formally invalid. So we come then to Tanna, which is and remains the leading case on challenges to self-certification decisions under the TCPA. In this case, the defendant had built a single-storey garden extension. He didn't have planning permission to use that as a self-contained dwelling. The LPA suspected that he had in fact done that and investigated him over a number of years. During all of that time, the defendant denied that he had used this garden extension for that purpose until the 4th of July 2014, when the big reveal came. He made an application for a certificate of lawful use, and in that application he admitted that for the last 4 years, or for at least the last 4 years, that extension had been occupied for residential purposes as a self-contained dwelling. So the local planning authority certified the 4th of July 2014 as the date on which it came to the evidence. Essentially, it said that's the date on which we had this signed confession, if you like, from the defendant that that had been the use of this extension for the last 4 years. The LPA then made its application on the 15th of December that year. Now, the defendant argued in court on the application by the LPA that the certificate was invalid. in his view, the correct date on which the LPA came to the evidence was actually the 19th of May 2014, so only 6 weeks earlier, but it made all the difference in this case. He said that was the date in May when I told you that I was going to apply for a certificate of lawful use, and you should have known at that time that I'd been fibbing to you all along, that I'd been lying essentially about why or what my use was of this extension. The judge in that case, Mr. Justice Collins, rejected the defendant's argument. Now, in terms of the principles, he set out the following core principles. Firstly, despite the use of the words conclusive evidence in the Act, the certificate can still be challenged by way of judicial review, and it therefore follows that the Magistrates' Court can also entertain a challenge to the certificate on the same public law grounds. However, a certificate can only be challenged on one of two bases. The first is that it's vitiated by fraud, and the second is that the self-certification decision is clearly or plainly wrong. The judge also opined that the Magistrates' Court can look behind a certificate if it, and I quote here because these remarks are important, if the decision could not meet the test of being a reasonable decision in judicial review terms. Now, those remarks are significant. In my experience, defendants quite like those remarks. They tend to leap on them because they suggest, if they're taken in isolation, that a defendant can challenge a certificate on the basis, basically, that the decision to certify the date was unreasonable against the facts. Now, it's important not to take those remarks in isolation because Mr. Justice Collins was clear that the threshold for a challenge was very high. He was at pains to stress, for instance, that a certificate should normally be determinative. He was at pains to stress that even if local planning authority investigative officers are incompetent in their investigations, that does not necessarily mean that the date that they certify is clearly wrong. And I'll explain in a second why he thought that there was incompetence in that case. He also stressed that the LPA is entitled to a degree of judgment. As we've seen, it's for the LPA to decide when it had sufficient evidence of the breach of planning control to justify the application. The judge also emphasised that the question of whether the evidence was sufficient is a question for the local planning authority because it's about the costs and the strength of the application. The local planning authority has to consider basically its litigation strategy. It has to consider the likelihood of winning in this PEO application, the cost of bringing that application, and it's very much up to the local planning authority to decide when it has enough evidence to bring that application. The judge was clear that the LPA is entitled to want a cast iron case. It shouldn't be forced to bring, for time limits reasons, an application which is half-baked or which is not supported by proper evidence. So it's up to the LPA to decide when its investigations should end, when it's got enough evidence to bring the application. And so those remarks that I mentioned earlier, the defendant's interpretation of Tanna, as I like to call it, shouldn't be taken in isolation. The rest of Tanna itself is quite clear that the threshold for challenging a certificate is very high indeed. Now, in that case, the judge held on the facts that the certificate was not clearly or plainly wrong. The defendant didn't, of course, allege fraud. But the judge expressed some reservation about that. He didn't reach that conclusion without hesitation. He described it as a borderline situation, and he described the LPA's officers, and these are his words, as being incredibly gullible in that case. During the course of their investigations, they'd seen, for instance, in 2011, a sign saying garden flat with an arrow pointing to the extension. In 2013, the extension had been registered for council tax, again, quite a clear indicator that it was being used as a self-contained dwelling. And then in May 2014, still some 2 months before the PEO application was brought, the LPA, the investigative officers, had found a tenant in occupation in the garden extension who claimed to have been living there for some time. But even despite those clear indicators over the years that the defendant was lying about not using that extension as a self-contained dwelling, even that gullibility, as the judge described it, did not render the certificate invalid, did not invalidate the date that had been certified. So the takeaway point with Tanna then is that it stresses the very high threshold for challenging a certificate, but it also creates some room for questioning the certificate as being clearly or plainly wrong. And it also creates some room for questioning the certificate as being clearly or plainly wrong on the basis of ordinary judicial review grounds. And as I say, defendants quite like to interpret Tanna as permitting them to argue that the LPA's certification decision was unreasonable on the facts and therefore should be struck down. It's very important not to read Tanna in that way. There are various problems with what I call the defendant's interpretation of Tanna. The first is that it turns the language in the statute on its head. Parliament is clear that a signed and dated certificate is conclusive evidence of the fact of the date. It also, rather oddly, simply applies general public law orthodoxy to say a certificate can be challenged on the usual public law grounds. Any public authority decision can be challenged on the usual public law grounds. If we allow such challenges, then we are clearly ignoring the clear attempt by Parliament to prevent those challenges from happening. So it's inconceivable, I would suggest, that Mr. Justice Collins meant that when he was making those remarks in Tanna. It's inconceivable that he was simply applying general public law orthodoxy and allowing standard JR challenges to take place on JR grounds in the magistrate's court. In practical terms, interpreting Tanna in the way that defendants sometimes like to interpret it also drags the magistrate's court into quite complex satellite litigation. It can be time-consuming and costly to rake through the facts of the investigative history for a defendant to do that and to examine witnesses in the process in the hope of saying, aha, you knew about this breach far earlier than you said you did. That can take a day or more of litigation in itself. And in some cases, the proceedings become disproportionately lengthy as a result of that. The defendant's interpretation of Tanna also ignores the margin of judgment that Parliament clearly intended to give the local planning authority. The statute clearly places the ball in the LPA's court. It allows the LPA to decide when it had sufficient evidence. It's not something that a court should be deciding, and so it shouldn't be entertaining challenges like these from defendants lightly. More to the point, this interpretation of Tanna is also incompatible with other cases, some of which Tanna relied on. So it's an important lesson, I would suggest, in not taking Tanna as a case in isolation, but also not taking particular remarks in Tanna in isolation. The surrounding case law context does give some important guidance as to how Tanna should be interpreted. There are three relevant cases here, two of which were relied on in Tanna itself. The first is Ambrosio. This didn't deal with the Town and Country Planning Act, but nothing really turns on that because it dealt with an identical provision in another statute. In this case, the High Court was clear that the certificate could only be challenged if there was a fraud or if the certificate was inaccurate on its face. Now just contrast that for a second with the remarks that Mr. Justice Collins made in Tanna, that the certificate can be challenged if it's clearly or plainly wrong. So we have two competing or apparently competing views here about when a certificate can be challenged: inaccuracy on its face, clearly and plainly wrong. And we have to look to other cases to determine what they mean. The judge, Lord Justice Auld, was also clear that there's no other way of going behind the certificate, so those are the only two avenues of challenge, that Parliament intended certainty, and therefore that challenges should be entertained only very lightly, and also that it's important not to impose an intolerable burden on the LPA by requiring it to justify its investigative history when it applies for a PEO. The purpose of the legislation was to allow the LPA to certify the date and for that to be conclusive evidence. So we come then on to Burwell, which is the second of the two cases that were relied on in Tanna. Again, deals with an identical provision in other legislation. In this case, the certificate was challenged and it did fail, but it failed for the very particular reason that it didn't state a date at all. The certificate simply said that the proceedings had been, quote, brought within a period of 6 months from when the evidence came to the LPA's, or in that case, the prosecutor's knowledge. That isn't good enough. There are, as we can see, as we have seen, formal requirements in the statute that the certificate be dated and that the date be stated. And so it failed for formal reasons in Burwell. But Lord Justice Keane went on to consider the scope for challenging a certificate in this case, and he drew upon Ambrosio and stated that the certificate must be plainly wrong in order to be challengeable. So once again, we have this use of clearly and plainly wrong in Tanna, in Burwell, and different use of inaccurate on its face in Ambrosio. Now, what does that mean? How wrong does a certificate have to be before it can be challenged? And this issue is only really resolved, properly anyway, in the very recent case of Chesterfield Poultry. This was not a Town and Country Planning Act case. Again, different statute, but material identical. And the High Court reviewed very usefully the authorities concerning self-certification decisions. Didn't consider Tanna, interestingly, but considered virtually every other case and extracted the following principles from the case law. The first is that there are powerful policy reasons for treating a certificate as conclusive. There are powerful policy reasons for not burdening the LPA or the prosecutor or whoever it may be with having to justify the investigation. Also, on this apparent disparity between a certificate being plainly wrong, being wrong on its face, the High Court was clear that plainly wrong means wrong on its face. And that tells us a lot, therefore, about what Ambrosio meant and in turn what Tanna meant. When the judges are talking about a certificate being clearly or plainly wrong, they are talking about it being so wrong that it's wrong on its face, that you could point, for instance, to the certificate and just say that is clearly the date is wrong. There may have been a typo, it may have recorded the wrong decade or something like that. You can look at it instantly and say that certificate is wrong. That's the kind of thing that you have to demonstrate if you're to challenge a certificate. So it means plainly wrong on its face, not simply wrong after a day of cross-examining witnesses and raking through the history of the investigation. The judges were also clear in that case that evidence to suggest anything other than the certificate is wrong on its face will be inadmissible. So unless you are trying to show a fraud or unless you're trying to show that the certificate is wrong on its face, you cannot even adduce evidence in court to do that. So very clear message being sent from Chesterfield Poultry there that the threshold is super high, super high. The court will not be striking down certificates lightly. So the key points then from this analysis. Well, firstly, Tanna remains the leading case on certification decisions under the TCPA. That's where lawyers should be going as a first port of call in cases like these. However, it is important not to read Tanna in isolation from the other cases. Ambrosio, Burwell, Chesterfield Poultry give crucial context to the meaning of Tanna. They explain what those remarks actually mean on the judge's part. There are various problems with allowing public law challenges, especially reasonableness-based challenges to self-certification decisions. Chesterfield Poultry, however, should resolve the matter of what you have to show if you're alleging that a certificate is clearly or plainly wrong. What you have to show is that it's wrong on its face, that it's patently defective. And finally, extraneous evidence, as we've seen, is inadmissible. So the two cases I would suggest looking to, first of all, are Tanna, obviously, in this context, but also Chesterfield Poultry. Those are two cases in this context. So I'll pass back over to Joe to discuss Welwyn Hatfield.
Thanks, Alex. So I started by saying that this whole episode was sort of kicked off by the Welwyn Hatfield saga, and that the PEO regime was, if you like, the legislative response to that case and that decision. And you might ask yourself, well, if the government has responded to the issue in Welwyn Hatfield with a particular regime, the PEO regime, is there any relevance left of the Welwyn Hatfield case and the particular point in Welwyn Hatfield that, and I'm paraphrasing, that no one should be able to benefit from their own wrong, basically. So just a reminder of what the Welwyn Hatfield or Beazley case was about. In a minute, you'll see a slide with a picture of the barn. If Alex can just advance the slideshow. So this is the barn that Mr. Beasley applied for planning permission for, and got planning permission for. It was a hay barn, agricultural hay barn. No suggestion in the application that it would be used for anything other than agricultural purposes. He built it, but inside he built, effectively as a second skin, a house, a dwelling house. And he and his wife moved in, and they amazingly lived there for 4 years. Obviously didn't mind not having a view. It wasn't great fenestration. And he then applied for a certificate of lawfulness. So this wasn't an enforcement case at the beginning, it was a certificate case. So he did the great reveal and said, please can we have a certificate that our house is lawful? Obviously 4-year rule because change of use, he said, to a single dwelling house. But the local planning authority said, and I won't go into the detail because it can get a bit rabbit holey, but they said, no, it's the 10-year rule here. It wasn't a change of use to use as a single dwelling house. It went to an inspector. So, sorry, Alex, I'm probably jumping ahead. Do you want to just advance one slide? That's what I've just said. And then another slide, please. The inspector found that Mr. Beasley had deliberately deceived the local planning authority. Now, at that time, there was no magic in the words deliberate deception or deliberate concealment. That's obviously the language of the PEO regime. There had been deception, so the inspector made certain quite helpful findings, which we'll come to in due course, but held that on the law, which, if you like, was blind as to the morals of things, that the 4-year period applied, the law was the law, and the certificate was granted. This had been a breach of planning control that had subsisted for more than 4 years, and that was that. Mr. Justice Collins, from whom we've heard already, overturned that decision, and then the Court of Appeal overturned Mr. Justice Collins, and it found its way all the way to the Supreme Court, which found that in that case, the 10-year rule applied and allowed the local planning authorities appeal. Now, I'm not going to go into the detail of that judgment because in large part it's not hugely relevant to the position today, but there were some comments that the Supreme Court made which I think are quite helpful. The first thing to note is that the Supreme Court went back to the, if you like, the original jurisdiction findings of fact that the inspector had made, in particular about concealment, and as you'll see in due course that becomes important. So some of the things that the Supreme Court said, first of all, that the time limits within the Town and Country Planning Act were there to allow a period for the local planning authority to discover, observe and investigate breaches of planning control. That was the point, if you like. So there was a sort of undermining of that point if, by hiding it from the local planning authority, if effectively stopping them from doing their job, you could then benefit from it and get yourself your effectively planning permission. It would be against that rationale if you could escape it by deliberate deception. There was also a lengthy discussion about this idea that you shouldn't profit from your own wrongdoing. You wouldn't expect in a parallel case a defendant to be allowed to keep a profit that he made through bribery or threats or some other unlawfulness. So why should you allow deliberate deception to lead Mr. Beasley to end up with a result that was financially very advantageous to him? It couldn't have been the intention of Parliament, said the Supreme Court, that the Section 171B would apply regardless of situations of deliberate deception. So where somebody had specifically tried to undermine the scheme, Parliament could not have intended that to be blind to that. And if the 4-year rule had been relevant, then it wouldn't apply, remembering that the Supreme Court held that it was a 10-year rule in this case because of some complicated stuff about the planning permission and so on and so forth, and whether there was a change of use. But had the 4-year period, so in a simpler case of simply changing use, then the Supreme Court would have disapplied it in a case of deception of this nature because of this idea that you can't benefit from your own wrong. That's paragraph 58 of the Supreme Court judgment. So far, so interesting. But as I've said already, what happened was that Parliament then intervened and enacted the PEO regime. And in a case called Jackson, the defendant, Mr. Jackson, argued that because the PEO regime had been enacted in the wake of Beazley, Welwyn Hatfield, that it had basically overtaken what you might say is the jurisdiction of Welwyn Hatfield, i.e. you can't benefit from your own wrong. The 4-year-old rule would not have applied in cases of deception, and everything was now bound up in the PEO regime. And in that case, the local authority had decided or had failed, or I can't remember exactly what the facts were in terms of why they hadn't, but they hadn't applied for a PEO. And Jackson said, well, look, that was your opportunity. In these circumstances, the PEO is the only way. So let us off. But Lord Justice Richards in the Court of Appeal said, no, that's not right. The PEO regime and what you might call the residual Welwyn Hatfield jurisdiction to look at deception are alternatives. Local authority can elect, they can pursue one or both, or of course none. And the key point that I think comes out of this is that, and this is paragraph 45 of Jackson, which is that the tests are rather different. So there's 2 points. First of all, that Welwyn Hatfield and the specific idea that you shouldn't benefit from your own wrong is wider than just deception. So it might be fraud, or it might be some other unlawfulness. And Welwyn Hatfield says that you shouldn't be able to benefit if you've used some unlawful means to obtain the current position. Whereas, of course, the PEO regime is quite specific about concealing the particular development. But perhaps more importantly and more relevantly, paragraph 45 of Jackson says this: there's an overlap between the PEO procedure and the Welwyn principle, but the overlap is far from complete. On the one hand, the PEO procedure is narrower than the Welwyn principle, since it applies only where an apparent breach of planning control has been deliberately concealed, whereas Welwyn extends to cases of dishonesty or criminality, such as bribery or coercion, which is the point I've just made. And then, on the other hand, the Welwyn principle applies only to particularly serious cases, whereas the PEO procedure applies where an apparent breach of planning control has, to any extent, inverted commas, been deliberately concealed. So the point being made there is that, if you like, the threshold, to use the language that Alex and I have used today, is lower in the PEO regime than it is in the Welwyn jurisdiction. I have to say, it's not immediately easy to find the basis for Lord Justice Richards' view that the Welwyn principle only applies to particularly serious cases. It doesn't say that in Welwyn, but that's a Court of Appeal judgment itself, Jackson, so that would be highly persuasive. And of course, the facts in Welwyn were particularly serious. There was a very deliberate concealment. So I dare say that probably is now the state of the law, that in order to get in on the Welwyn principle, you have to show that the deception has been particularly serious, where of course on PEO you don't have to do that. You just have to show, as we've said, that the apparent breach of planning control has to any extent been deliberately concealed. Of course, the other point that's made here is that the PEO procedure might avoid the need for an enforcement appeal at all. Lots of enforcement appeals are only brought on, or at least substantively on, ground D. We're immune. I mean, there might be a ground F and a ground G appeal thrown in, but if you go for a PEO first and knock out the time point, that may negate the need for an appeal altogether. So next slide then, please. Again, this is still Jackson. Welwyn may still be useful. Again, same sort of point as I've already made. Local planning authorities may well face difficulty obtaining information as to site history and so on. And the point that we've raised already, local planning authority may have started enforcement proceedings not realising that there was deception, and that happens quite often. Or at least, I dare say, could happen quite often. And if the appellant in Jackson was right, that would mean that those enforcement proceedings would fail, and that you had to then go for a PO, and it may be that you weren't in time to do so. So the bottom line of all of this is, what's left of Welwyn? Well, quite a bit. You can use and rely on the Welwyn principle in, for example, refusing a certificate. So the PEO regime, as you know, only permits the taking of enforcement action beyond the deadlines. Can you refuse a certificate where there's been evidence of deception without necessarily going thereafter for an enforcement notice? Well, yes, you can rely on the Welwyn Hatfield principle and so on. You don't even have to use the PEO regime at all. If you've got a case where you think there is sufficient evidence of particularly serious concealment or wrongdoing, then you can take a risk, if you like, and not bother with the PEO regime and just rely on the Supreme Court in Welwyn. My feeling is in that latter case, that would be a risk, and why wouldn't you go for a PEO? One of the great things about the PEO regime is it provides, if you like, a relatively early opportunity to test the evidence of concealment. If you get your PEO in the magistrates court, that does away with the ground D, the prospect of ground D appeal altogether. If you don't get it in the magistrates court, you're pretty unlikely to be able to win on a ground D appeal on the Welwyn Hatfield principle. So it provides a good, relatively early test for that. I think that's that slide dealt with. What we're going to do next, we've got about 5-10 minutes left. We're going to just deal really quickly, I think, with some practical tips and then move on to some of the questions that you've asked. Just before we do that, while Alex was talking, I've tried to answer a few of you in writing on the Q&A thing where the answers are relatively straightforward. So I think I've answered 3 or 4 of those. And it may be that some of these tips also lead us to some of the answers. One of the questions that lots of you are asking, and we haven't really touched on yet, is what will amount to deliberate concealment? How far does one need to go? And I wonder if we should just deal with that first, Alex. And I'll just give some views, and then Alex, perhaps you can take over. Is it enough that they haven't declared the property for council tax? Well, in my view, no. What you've got to be looking for here is something positive, something that active steps they've done to, sometimes it's said that's intended or calculated to undermine the planning process. There's something within the process of planning, investigation, so on, that tries to throw them off the scent. Active rather than passive is another distinction that's sometimes made. Now, there have been a couple of, obviously these are all completely site specific. There's no general rule, but there have been a couple of inspector decisions in the last 4 or 5 years which say some fairly helpful things about what you should be looking for. One of them, Watling and Kings Lynn and West Norfolk Borough Council, the inspector there said this was a change of use, agricultural land to residential, as so often. The inspector said that the appellant kept a very low profile so far as matters such as council tax and refuse collection were concerned, so passive rather than active. And then the inspector said, none of those matters, in my opinion, amounted to positive deception of the council, such as that undertaken by, amongst others, Fiddler and Beasley. The appellant didn't make any positive and deliberately misleading false statements, which successfully prevented discovery of the developments by the council. In that case, there was no deception. And then another one called Leon and Hartsmere. Council include, this is the inspector in that case, again, creation of a new residential unit. Council includes in support of this case, there was a positive deception, the failure to pay council tax, failure to notify the council street naming and numbering department of the new dwelling, although such notification was not required by law, failure to involve building control and only been on the electoral register from a particular point. And again, in that case, Inspector, I have concluded that at their highest, these failures were in this case acts of passive omission amounting to keeping a low profile and not positive deception. Again, the argument around deception failed there. That's a slightly depressing view if you're a local authority. Those 2 cases are the only inspector decisions I could find on it. I think the bottom line for me is that you need something active. Because of the word deliberately concealed, you need something more than just non-notification. We all know that you're not required to tell the local planning authority that you're about to breach planning control, but you are not entitled when the planning officer comes to say, oh no, that's just a barn, or something of that nature, or to make planning applications which are themselves misleading as to the present status of the barn, for example, as happened in Beasley. Alex, I don't know if you want to add anything to that, which seems to be the sort of central question.
Yeah, other than say I would agree. I think council tax and electoral information is significant, but not, as Joe says, because merely failing to register for council tax or failing to put yourself on the electoral roll suggests deliberate concealment. It can be significant as part of a pattern of behaviour, and very often it'll be a combination of these things that leads the court to believe that the concealment was deliberate. It might be, for instance, that somebody has not put themselves on the electoral roll because they have no interest in voting. Now that seems to be a fairly plausible explanation. But actually, if you look at the letters that local councils tend to send to people, they will usually include in bold type a warning that failing to put yourself on the roll is a criminal offence, and that tells you quite a lot about the lengths to which someone might be going to disguise residential use of a building, for instance. It might be that somebody is not on the electoral roll or registered for council tax, but they suspiciously put themselves on the roll and start registering for tax shortly after they've been rumbled by the local planning authority. That tells you something about why they weren't on there in the first place. So I completely agree. I don't think those things of themselves will get you home and dry in terms of demonstrating deliberate concealment, but they might suggest a pattern of behaviour that, if you scratch the surface a bit more, it is very useful to you in terms of an LP, if you're an LPA, in terms of making your application.
Yeah, I think that's absolutely right. And just to add a point about the jurisdiction that you're dealing with here, both of the inspector decisions I read out are by effectively technocratic inspectors. I don't mean that in a disrespectful way, but they are largely imbued in the world of planning and will look at things on a relatively technical basis. If you're trying to get a PEO, you're in a very different jurisdiction. You're in front of the magistrates, who are, if you like, used to ne'er-do-wells and scumbags coming along and telling lies in the witness box. My feeling is that you'd have a much easier run in front of a bench of magistrates on the kind of basis that Alex just spoke about. So not necessarily a smoking gun, but a series of 5 or 6 patterns or pieces of behaviour that together add up to something nefarious. I think you'd be more likely to get home with the magistrates than you would with an inspector. That's just my view. I mean, some inspectors maybe not, that's not true of, but my feeling is that you'll have an easier run in front of magistrates where you can show a series of examples of, and basically just say to the magistrates, look, add all this up together. Is this the action of somebody who's being straightforward? And while that's not quite the test, I think it's then only a short hop, skip and a jump to get the magistrate to say that this was a deliberate concealment. Just on one little question that's just popped up, something I just said, I've actually answered it in writing. I think Tom Wicks, it was you that asked it. I just said a moment ago that if you get a PEO, that would do away with a ground A appeal against an a ground D appeal against an enforcement notice. What I mean by that is, if you get a PEO and then take enforcement action, i.e. serve an enforcement notice within the enforcement year provided for by that PEO, then the recipient of the enforcement notice can't argue immunity, or at least can't argue the kind of immunity that they would have argued but for the PEO. So the effect of the PEO, you remember I said that when he lifts the Section 171B time limit on taking enforcement action, extends it by a year and 22 days, if you like. So they then couldn't pursue a ground D appeal to it because it wouldn't succeed, because you would just point to the PEO and say, actually, although 4 years had elapsed, we were, based on the PEO, entitled to take enforcement action within the enforcement year. Alex, over to you for some practical tips and or answer some questions or whatever you want to do.
Okay, so we'll start with practical tips. I think Joe and I are going to take these point by point, but they are a summary essentially of what we've said so far. Our suggestion is that if you're minded to apply for a PEO, or you're dealing with what you think is a deception, concealment kind of situation, then this would be a sensible method to approach the issue. First of all, obviously, identify what your breach of planning control is, in order that you're able to determine what the appropriate enforcement period is. It might be that you've got plenty of time and that you don't need to entertain a planning and enforcement order application. It might be that you are pressed for time. It might be that there is some disagreement perhaps about which, as in Welwyn itself, about which enforcement limitation period applies, in which case you might want to make a PEO application to cover yourselves. I'll pass over to Joe for the other points on that slide. I think you're still on mute, actually, Joe.
I am, yeah, my first muting error of the day. There are usually more than that. It's usually the other way around too. So I think, as Alex says, most of these points we've sort of covered. Relevant time limit we've certainly dealt with, but you need to get that straight. What precisely is the concealment deception? Again, vital to get that straight. Doesn't need to be smoking gun. I've dealt with Welwyn Hatfield or the PEO. I mean, I think the answer is it's a PEO unless for some reason you can't. I can't really see there would be any particular tactical reason to not go for a PEO. I think in most cases you might as well have a crack at a PEO. Strictly, if you apply for and fail to get a PEO, you can still, there's nothing about that disentitles you from relying on the Welwyn principle, but it will obviously be much harder if a magistrate's court has said no. And that reminds me, one of the questions that was asked was, is there a limit to how many PEOs you can apply for? The answer is no. You can apply for as many as you like in respect of as many different breaches as you like, but if you're applying for making repeat applications for PEOs in respect to the same breach, you're going to have to show some kind of change or new evidence for your second and subsequent ones. Anything else from that side, Alex, or should we move on to?
Yeah, simply to point out the glaring typo, which I'm sure many of you have spotted, and I apologise for. The last point on that slide, when did the LPA have evidence of concealment? The eagle-eyed among you will have spotted that is wrong. The question is, when did the LPA have sufficient evidence of the breach of planning control to justify the application? So that's explained in 171 BB2, but just don't get caught out there like I did.
I assumed that was your practical tip, Alex. Was
yes, the practical tip was don't be me.
Exactly. And then the next slide. I mean, again, Alex has. Well, we have more or less covered all of these, I think. Be robust on the self-certification. Just go back and have a look at Alex's slides, which we can make available to you about Tanna and so on. It really is the very rare case, I think it's fair to say, where a court should even entertain, let alone find favour with a challenge to a self-certification decision. That it really ought to be just a formality in each case. I've said already that you can make your PEO application before the time limits expire if you're concerned about them expiring. There is sometimes an overlap between the point at which you have enough evidence for the breach and the time limits expiring, and it might be worth protecting the position if that's coming imminently. Remember the breadth and benefits, which we've talked about already. And then documentary evidence. I mean, really, I think that this touches on what we've spoken about already in answer to those questions about what we're looking for. Clearly, things like council tax records, correspondence. Sometimes there are site visits in respect of different breaches of planning control or suspected breaches of planning control, which might add something to the picture. You know, if you I did a case in Devon a few years ago where it wasn't a PEO case at all, but it was a grandee appeal about a change of use. And it was one of those sites, and they so often are, where there were kind of multiple suspected breaches of planning control across the site. And there was actually quite a good, rich history of visits. And quite a number of the visits about other breaches of planning control, there was notes of the occupier of the land being kind of evasive about the particular, it was the change of use of a building to a residential dwelling. And again, they're the sorts of things that you might well want to bring in and show, well, actually, if he was being straightforward about it, he wouldn't have steered us away from that building or so on and so forth.
Yeah, I don't really have anything to add on that slide, other than to say that as someone who does quite a lot of social housing work as well, and in particular housing fraud work, there's quite an obvious crossover, I think, between an investigation that a council might carry out for the purpose of determining which of two flats someone is living in, and the kind of investigation that an LPA might carry out when it's trying to work out whether a building is being used for residential use. So if you're an officer at an LPA, you don't deal with investigations like these very often. It might be worth, if you're a busy council with a busy housing department, just speaking to colleagues in the housing department as well, because in my experience of housing, they tend to be very forensic in terms of the way they gather their evidence and build up their picture. And really, it's partly about what you say when you're in court, but it's about laying the groundwork and making sure that your investigation is as tight as it can be before you get there. So it might be worth maybe having a chat with them if you're new to this kind of thing.
Indeed. We're 7 minutes past 12 already, and we promised you that we wouldn't go on beyond 12. Alex, and there were lots of other questions asked. I know we've answered some of them. Is there anything, Alex, you particularly wanted to deal with from the questions that were there?
There were some that I'd highlighted from the spreadsheets that were sent around when people signed up with their questions, but I think we've addressed them all. I'm just looking at them now. I think the ones that I was going to answer have been addressed.
Yeah.
So nothing to add there.
similarly, a lot of them, well, I hope a lot of them have been answered in the course of it. I think both Alex and I would say, and in fact, the next slide, I'll just embarrass Alex with the next slide.
Oh, yes, sorry.
If anything was unclear, Alex has written an extremely helpful and enlightening article in the JPL there about this exact issue. So it's well worth looking that up. And actually on our Chamber's website, there's a summary of that article too. So that's your first port of call. If there's anything unclear post that, which I can't imagine is possible, then please feel free to email one or both of us and we'll do our best to answer them. Sorry that we haven't managed to answer all of your questions. I hope we've managed to enlighten you a bit about the PEA regime. Yeah, hopefully those of you that are from local authorities, and it looks like lots of you are, will start to consider using these. They're I think, very much underused at the moment, and it seems to me, subject to Magistrates Court dealing with them in the lockdown and post-lockdown era, a very good way of getting around cases where there has been deception.
So I think with that, we'll just thank everyone for attending, and so we hope you enjoy it. The slides will be circulated. The recording will be available on our website. So if you've missed anything, it's all there. But thank you for attending.
Thanks very much.